May it please the Court, I am here with Mr Julian Milford for the appellate, British Airways. My learned friends Michael Ford QC, Simon Cheetham QC and Jack Mitchell appear for the respondent, Balper. All of us, apart from Mr Ford, were in the hearing below last week. My lord and my lady. As the Court knows, this is an urgent appeal against an extemporary judgment given by Mrs Justice Elisabeth Laing last Tuesday, the 23rd of July, in which she dismissed British Airways' application for an interim injunction to restrain Balper from taking part, or from calling, I should say, its members to take discontinuous strike action, those members being pilots.
Yes, sir. Mr Governor, all members of the Court have read all the papers which we were asked to read in the reading list, so we do know what this case is about.
I'm very grateful. May I?
I've not been through all the exhibits to the witness tapes or anything like that, and so if you need to go to those, then you'll have to take them to us, but we've read everything else.
I'm very grateful. In that case, I will focus on the point of law that's at the heart of this appeal, and also, to do so, take the Court to the statutory provisions and to the key authorities, and I won't waste the Court's time with a broad introduction. May I, however, thank the Court on behalf of all of the parties for making itself available at such short notice to deal with this appeal.
Well, that's our job. I mean, this matter's got to be decided urgently.
Quite so. But may I also thank the judge below, because she approved the
Yes.
transcript of the judgment at very short notice indeed. As the Court knows, this appeal now revolves around only one of the issues, one of the three issues that was below, and the issue concerns the obligation set out in section 226A of the Trade Union and Labour Relations Consolidation Act 1992, which I'll call TULCRA, which requires trade unions, at the moment when they give a notice of ballot, to provide employers with certain information. And the key information for present purposes is the information relating to the categories of employees who are to be balloted and the numbers within the categories that are to be balloted. As the Court knows, Mrs Justice Elisabeth Laing held that what was done in this case, which was to categorise pilots by rank, captain, first officer and so on, was sufficient, and what we respectfully submit is that they should have gone on to also to categorise pilots by reference to their fleet, and the Court's seen the evidence in relation to the fleet. Happily, in this case, there is no dispute of fact between the parties on the issues that are relevant to this first issue, and they've been very helpfully set out in the judgment of the learned judge. As the Court will also appreciate, this is the second occasion in 6 months in which the categories issue has been dealt with at an interim injunction stage, the other being the Virgin Atlantic Airways case in front of Mr Justice Chowdhury. And the central difference between the approach taken by the two judges below concerns the purpose for which the information requirements in section 226A are imposed. And it comes down to this, that we respectfully submit, and this was accepted by Mr Justice Chowdhury, that the legislative purpose is to assist the employers in two ways, but one way is by far the predominant way. The predominant way is to assist the employer to prepare contingency plans to deal with the impact of the industrial action. The second benefit for the employer is that by knowing the categories of employees to be balloted, it has the opportunity to target its representations to the members as to why they shouldn't vote in favour of industrial action. And those purposes were accepted as the statutory purpose by Mr Justice Chowdhury, and that informed his conclusion in the Virgin Atlantic case that a different trade union in that case had failed to comply with the statutory requirements. However, in that case, the issue was not about fleets. The issue was that the union hadn't even given rankings when it had given the categories. All it had said was that they were in the category of pilots. In the present case, in contrast, Mrs Justice Elisabeth Laing took the view that whilst originally the legislative purpose was as I had just described, And whilst in the second of the three iterations of section 226A that I'll have to take the court to, the statutory purpose was expressly stated, she inferred from the fact that the same wording did not appear in the current version of section 226A, which has been enforced since 2005, that that is no longer the statutory purpose. And therefore she did not evaluate whether BALPA had complied with the categories requirement in the present case by reference to what we say is the statutory purpose. And therefore we respectfully submit that the learned judge misdirected herself in that regard. So this is not a case in which we are saying that having directed herself correctly, the judge reached the wrong conclusion by applying the law to the facts. We submit that she misdirected herself and therefore did not apply the right law to the relevant facts. Of course, if we're right about that, then we would respectfully invite this court to have regard to the findings of fact made by the judge, and we will submit that applying the law, the correct law, to those findings of fact, the plain conclusion should be that the categories obligation in these circumstances extended to an obligation to give the information about fleets, as well as information about ranks. My lords, my lady, I won't, unless you wish me to do so, take you through the general and agreed approach to industrial action injunctions or to this court's power to intervene on appeal, because they are common ground. They've been set out in both of our skeleton arguments, and so far as the court's approach is concerned, also in the judge's judgment. But the key point is that the American cyanamide test does not apply in these circumstances. We have to, as the claimant below, have to persuade the court that the obligation, that the likelihood is that at full trial, on the basis of the evidence that was before the judge at the interlocutory stage, it was more likely than not that there would be a finding that there was a breach of the categories requirement.
Well, the court still has a residual discretion.
Yes.
But as I understand it, it seems to be in common ground that if it was to be adjudged that you were the more likely to succeed at trial, then you should get the injunction. Whereas if you were adjudged not to be the more likely to succeed at trial, then contrariwise your claim should be dismissed.
Quite so. That's recorded at paragraph 27 of the judgment.
And that remains the position today.
That remains the position below, sensibly, if I may say so very fairly.
Yeah.
The union has accepted that that would be the position.
Well, both of you accept that.
We do indeed.
Right.
May I therefore move straight to taking the court to the relevant statutory provisions? Which were found in tab 1 of the authorities bundle.
I thank those responsible for preparing the papers. They seem to be very well prepared indeed.
I'm very grateful, and they're in the back of the book, my lord.
Yes. Right, do you want us to go to
Tab 1,
Tab
my
1,
lord,
yeah.
and within that, section 219. The starting point, of course, is that ordinarily inducement to breach of contract is a tort. And what happens under Tolcra is that provided various requirements are complied with, the union is immune from suit for the tort of inducing breach of contract. So section 219(1)(a) says that an act done by a person in contemplation or furtherance of a trade dispute is not actionable in tort on the ground only that it induces another person to break a contract. Now, pausing there, the phrase, an act done in contemplation or furtherance of a trade dispute, is a term of art defined in section 244, but there's no dispute in this case that the industrial action would be in pursuance of a trade dispute as so defined, because it's about a pay dispute. So that's the general immunity, but it's qualified by subsection 4, that subsection 1 has effect subject to sections 222 to 225 and to sections 226, requirement of ballot before action by a trade union, and 234A, requirement of notice to employer of industrial action, and then it goes on with a passage I don't need to read. So in order to comply or to benefit from the immunity, a trade union must comply with the requirements that follow. The next provision that I should show the court is section 226. This is what brings in the obligation to comply with section 226A. At 1, an act done by a trade union to induce a person to take part in industrial action, A, is not protected unless the industrial action has the support of a ballot, and B, where section 226A fails to be complied with in relation to the person's employer, is not protected as respects the employer unless the trade union has complied with section 226A in relation to him. The court would then kindly turn to 226A itself, and may I preface what I'm about to say by repeating that there are have been historically three versions, including this one of section 226A, and I will be taking the court to compare each of them, but I'll start with the current version. And at 1 provides that the trade union must take such steps as are reasonably necessary to ensure that, at A, there's a prescribed period of not later than the 7th day before the opening day of the ballot, the notice specified in subsection 2 and the sample ballot paper is received by every person who it's reasonable for the union to believe, missing out words, will be the employer of persons who will be entitled to vote in the ballot. So that's the obligation to give a notice to the employer 7 days before. In this case it was on the 19th of June. At 2, that notice is a notice in writing specifying two things at A and B, and then at C, containing the lists mentioned in subsection 2A and the figures mentioned in subsection 2B, together with an explanation of how those figures were arrived at. And Roman 2 is concerned with something that's called check-off. Where some or all of the employees concerned are employees from whose wages the employer makes deductions representing payments to the union, either those lists and figures and that explanation, or the information mentioned in subsection 2C. And the list that has to be contained in the document are a list of the categories of employee to which the employees concerned belong, and a list of the workplace at which the employees concerned work, and at 2B, the figures are A, the total number of employees, B, the number of the employees concerned in each of the categories, and C, the number of the employees concerned who work at each of the workplaces. And at 2C, the information, this is specific to check-off cases, is such information as that will enable the employer readily to deduce the total numbers, the categories and the numbers within the categories, and the workplaces and the numbers within the workplaces. So if there's check-off already, the obligation to provide specific information is reduced somewhat. At 2D, there is a saving for the unions. The list and figures supplied under this section, all the information mentioned in subsection 2C, must be as accurate as is reasonably practicable in light of the information in the possession of the union at the time when it complies with subsection 1A. The union doesn't have to get it absolutely right. 2E concerns an issue that we will see troubled the courts in the past, which is what in the possession of the union means in this context. And the answer is, it is information held for union purposes, A, in a document, whether in electronic form or other form, and B, in the possession or under the control of an officer or employee of the union. And may I just observe that the word officer there has a particular meaning in section 119, which is not one we've included in the bundle, but I do have spare copies. The point about the word officer rather than official is that something that's only possessed by a shop steward will not count for this purpose. An officer of the union means an officer of the governing body of the union or a trustee of the union. So what this does is it narrows the meaning of information in the possession of the union, so it's actually only information that's possessed either by an employee of the union or by the governing body of the union. 2G states expressly that nothing requires a union to supply an employer with the names of the employees concerned. And at 2H, as you would expect, the definition of employees concerned is those employees of the employer in question who the union reasonably believes would be entitled to vote in the ballot. Important to note that the word categories is not defined either in section 226A or anywhere else in Tolkien. And finally, though it's of no relevance for present purposes, section 234A is the second stage at which the union has to provide the employer with notice. Actually, it's the third stage. The second stage is when the result of the ballot is arrived at, and at that point, the union has to notify the employer. I think that's section 231. Yes, section 231, they have to notify, the union has to notify the employer of the result of the ballot, and at section 234A, when they decide actually to call the industrial action on at least 2 weeks' notice, the union has to send a further notice which contains similar information of lists, categories and workplaces, except this time it relates to employees who are to be called to take the industrial action rather than employees who are expected to be balloted. But apart from that, the wording is the same, although it doesn't appear in the judgment. Mrs Justice Elisabeth Laing in the course of argument observed that the word categories must have the same meaning in these two provisions, and everybody agreed that that must be right. As for the facts of this case, unless the court wishes me to do so, I'm not simply going to read out the statement of facts that we've summarised in our skeleton argument in 9 propositions. All of those were taken directly from the judgment of the judge.
Well, the judge sets out the background facts very fully, and as I understand it, neither of you disagree with anything she says.
Absolutely.
And neither of you says she omitted anything either.
No.
Right.
So the key point is that she recognised that BA needs to plan in relation to each fleet in respect of industrial action. And it was also common ground that BALPA had in its possession, in the sense defined in the statutory provision, the relevant information that would have enabled it to categorise pilots by fleet. May I move on then to my submissions on the point of law as to the true meaning, purpose and effect of the notification of the information requirements in section 226A. And I'm going to do it in this way, if I may. I'm going to show the court 2 short passages in the Virgin Atlantic case where we say the learned judge got it right. Then I'll take the court to the reasoning of the learned judge in the present case. Then I will take the court through the legislative history and make my submissions as to why the learned judge was wrong, that the legislative history supports the conclusion that the purpose is now not what it used to be. And then I will take the court through the authorities, particularly focusing on 2 authorities of this court, RMT and London Underground, and RMT and Circuit. But I will also then deal with the other authorities that are referred to in my learned friend's skeleton argument and my own. So may I begin?
Just in terms of planning, how long do you think you're likely to be?
Yes, my learned friend asked me this morning, and I said that ideally I'd be about 2 hours. Now I appreciate that this is down for a day, and I will be as short as the court wishes.
That's right. I just want to make sure that Mr. Ford has an equal opportunity to
quite so.
Even though obviously you'll be laying the groundwork, so you're likely to be a little bit longer than him.
Yes.
But right, anyway, we will conclude the argument within the day.
Well, absolutely.
Well, I think we'll require you to anyway, so good. Thank you.
Thank you. So may I ask the court to turn to tab 13 in the authorities bundle, which is the Virgin Atlantic case. And I'll return to this at the end of my review of the authorities, since it's the last in time. But I just wished at this stage to show the court 2 passages. The first is at paragraph 48 on page 12. The page numbering is at the top of the photocopy. Mr Milford and I were counsel for the airline in this case as well. And at paragraph 47, His Lordship notes that we derive 4 propositions from the authorities. And at paragraph 52 over the page, he agreed that these propositions fairly summarise the relevant principle. And the first one, and the key one for present purposes, is that the category requirement is a real requirement and not a bare formality, and its purpose is to enable the employer to make plans to avoid or mitigate industrial action. The information as to category must be useful, and reliance is placed upon London Underground and RMT for that proposition. Then at paragraph 61 on page 15, where he sets out his conclusion, His Lordship drew upon the statutory purpose in coming to his conclusion. So he says the starting point is that the obligation is only to provide general job categories. However, as I've said, that doesn't mean that any general description of a job will always suffice, irrespective of the particular circumstances. These circumstances are important because of the legislative purpose behind the giving of this information. It's to enable employers to take action to mitigate or avoid the consequences of strike action. In some cases, the general job category may well suffice. That may be because there are no other types of employee within a particular location, or it may be that the work done by that category of employee doesn't differ in any fundamental respect as between the different grades of employee or different types of employee carrying out that work. Where, however, there are fundamental differences between different employees falling within the same general job category, the obligation can, in my judgment, include a requirement to provide categories which are more specific. Perhaps since we're here, at paragraph 65 over the page, he said in that case, in terms of planning for the effects of strike action, it was in his view necessary for the claimant to have some idea of the numbers of captains and first officers likely to participate. And at 69, he says it would be for the claimant to use the information provided to it as to the number of captains and first officers affected by strike action and to plan accordingly. That information may not be perfect in terms of the rosters to which the pilots would be assigned. However, it provides a valuable starting point in what is undoubtedly a very difficult exercise. So there's a recognition that it doesn't give the employer necessarily everything that the employer would like to have seen. May I move then, please, to the reasoning of Mrs Justice Elisabeth Laing in this case, and you'll find the judgment in the core bundle at tab 5. And I know that the court will have been provided with the approved version, although the approved version, apart from formatting, was exactly the same as the version that had been submitted by the Parliament.
Just before we move on, if you go to paragraph 51 of Mr Justice Hamblen.
Yes. My Lord, yes.
This is an absolute obligation. It does not matter if the employer can work out who the employees are from its own information.
Yes.
Well, in one sense, that must be right, because you're looking to see what the statute requires, and the statute requires you give categories. But in terms of planning, could not British Airways work out which of these pilots were long haul, which short haul, and so on and so forth?
My Lord, no.
I'm just looking at the matter of merits. Can British Airways work out for itself?
No.
No,
it can't. It does know that a lot of its pilots are members of BALPA. Yeah. It doesn't know exactly how many, because there are only 59 who are in Chekhov. Obviously, those who are in Chekhov do know that.
Yes.
All the others, and there are over 4,000 others, BA doesn't know one way or the other who is and who is not a member of BALPA, because that's not information it's entitled to, and it's not information an employer would ordinarily be given. Although BA does know anecdotally that a substantial majority of its pilots are members of BALPA, it matters enormously for the contingency planning to know as specifically as possible how many within each fleet are going to be balloted, because even very small differences in numbers within fleets may make a big difference to the number of planes that can be got off the ground under the industrial action. That was stated in paragraph 62 of Mr. Winstanley's first witness statement, and it's also expressly referred to in the learned judge's judgment, paragraph 15. And in Mr. Strutton's witness statement, which the court may have seen, he refers to the percentages being around about 90%, but then when he refers to particular fleets, it's clear that it varies by 5 or 6% in different directions in the different fleets. So it is information BA didn't have, and information that would, as Her Ladyship found, genuinely been of value to BA in the organisational steps that it can make to minimise the effects of the industrial action.
Thank you. Right, you wanted to go to Mrs Justice
Laing's judgment, please. It's tab 5 in the core bundle. And I'm going to deal with the discussion which begins at paragraph 78. Page 53b. She refers to the point about the legislative history, and that, as I keep saying, but I am going to do it, I'll take the court very closely through the legislative history. But the central point is that in version 2 of section 226A, the statutory purpose is expressly stated. In version 3 it is not. And she goes on to say that it's difficult to see how, given that Parliament has expressly removed the reference to planning from the statutory language, it can be right to submit that planning can be the primary or indeed a purpose of the current statutory provisions. So Her Ladyship's view was that planning to deal with the consequence of the strike is now no part whatsoever of the current statutory purpose. At paragraph 8...
Well, I think, I speak myself, it can be identified that the rationale for this provision is to enable an employer to be prepared. That's the underlying rationale. But it does not follow that it is a statutory purpose for the purposes of construing the obligation.
My Lord, not necessarily, but in this case, I respectfully submit that that is the statutory purpose, and I'll seek to persuade the court through two authorities of this court that that is so. And
So do you think you need to distinguish between the underlying rationale for this provision on the one hand and what a union is required to do under section 226A on the other? You do need to distinguish that.
Indeed, sir, and I'll be rigorous if I can be in so doing. But I emphasise at the outset that we will say that there has to be a statutory purpose for this provision. Otherwise, it would be a pointless, onerous task to impose on the trade union for no reason at all. So one has to identify, in my submission, a statutory purpose. And the only statutory purpose, as I will come on to submit, that there can be, is to assist the employer in making its planning. If that's right...
I doubt Mr Ford would disagree with you on that.
Well, my Lord, I think he does disagree with me on that, because it's contradicted in his skeleton argument.
All right, well, he can speak for himself.
Quite so, but this is an important point, because in my submission what is absolutely clear from the learned judge's judgment is that she directed herself that when analysing whether there had been compliance or not with section 226A on the facts of this case, she had to leave out of account altogether the idea that the statutory purpose for this provision was to assist the employer in making plans to deal with contingency planning. And I derive that in particular from the sentence I've just read, the second sentence in paragraph 78. It's difficult to see, and it's clear that she just concludes that it isn't right
submit.
I beg your pardon?
Right to submit.
Yes, but I'm going to say that if you read the rest of the passage, it's wrong for us to submit that planning can be the primary or a purpose, because planning is not any part of the statutory purpose for section 226A. That's the conclusion that this learned judge reached, in my respectful submission. And that, in my submission, is clear not only from that sentence. She then says at 79, first sentence, I do not consider that I get much help from the decision of Lord Justice Robert Walker in the RMT case. That's a reference to the passage in the RMT case that we'll see shortly, in which Lord Justice Robert Walker states that the statutory purpose is, as I've just described it, the planning purpose. She then goes on to refer to the fact that version 1 and version 2 of 226A were very differently worded, as they were. She says that she considers that the best guide to the purpose of the current provision is the language which has been used by Parliament, and she then sets it out there, although that is actually the requirement in subsection 2C. That's the requirement to do with Chekhov. That's not the requirement for cases like this. That's a requirement in cases where everybody's on Chekhov.
But it gives an indication of the purpose of the information, because the information is broadly similar.
Indeed so, and of course we would respectfully submit it supports our submission because it reinforces the point that the idea is to give the employer practical help. The reason it's different for Chekhov is the employer already knows quite a lot of stuff, and therefore the practical help it needs is different from a case like this, where the employer doesn't know the identities of any of the union members.
But to what extent is the union required to go the full mile to give practical help? Well, why should it?
Because
that's an irreducible minimum, categories. But the logic of your argument suggests is that the unions, in all cases, must give the fullest possible information to enable employers to plan in the fullest possible way. Well, how can you get that out of the language?
My Lord, I don't need to go that far, because what we say they should have done in this case is not the fullest possible.
Well, I think it's quite striking the way you sought to argue the waterside point below. I know you don't pursue that on appeal, but you know the logic of your argument drives you to that kind of extremity.
Well, as my Lord sees, we have withdrawn from
I can see the
waterside.
I can see the tactical shrewdness in doing that, frankly. But it rather highlights, though, just the parameters of your argument, because you do seem to have been going down the road. We want the fullest possible information to enable us to plan in the fullest possible way. Now, I know you don't pursue the waterside point, but it's striking that you were pursuing it below.
Well, my Lord, we don't say that we need or are entitled to the fullest possible information. What we do say is that the amount of information that is required in a particular case is a question of fact and degree. That is the way it's been approached in the Unison case that I'll show you of this
and
court.
You would say that fits with the fact that Parliament has not sought to define categories.
Exactly so.
Right.
And fact and degree is an objective test, not a subjective test. It's not what the union chooses to give, because the union, of course, has a motive to be unhelpful, as this union, we say, was in the present case.
Well, but that's the whole point of strike. You're not trying to help the employer. That's the whole point of going on strike.
Absolutely so, but we have the Trade Union and Labour Relations Consolidation Act, which puts a brake on what a union can do. The whole point of that legislation is to...
you say it's fact and degree, in each case to be assessed objectively.
Quite so. But, fundamentally, each case to be assessed objectively against the statutory purpose. The statutory purpose being to assist the employer.
The only purpose.
The only purpose of this specific provision. I'll show the court in a moment. There are other provisions in TULCA which have a different purpose. This one is to assist the employer. Otherwise it would be completely meaningless. And I got to paragraph 80. Her Ladyship said it seems highly significant that the purpose is no longer said to be to enable the employer to plan. In my judgment, the currently stated purpose for which the employer is said to be required in 2C gives focus to what the categories mean in that particular context. So once again, in my respectful submission, particularly given the way the case was argued, as she describes the argument earlier on in her judgment, is that her conclusion is that helping the employer to plan is no part of the statutory purpose of this provision. And to that effect, if one turns back a page to paragraph 76, where the union's argument is set out, she says that the defendant's riposte to the approach of the claimant on the basis of Mr Winstanley's first statement that the information is necessary to enable BA to plan is that far from making the law simpler and clearer, that approach does the opposite. It makes it harder for the union to categorise. The purpose of planning is no longer a statutory purpose. It's submitted that BA's approach gives exclusive prominence to that purpose and removes the union's discretion to categorise. That introduces the uncertainty, which was the trend of the provisions, and which the amendments were trying to remove. So, the sentence there, the purpose of planning is no longer the statutory purpose. And in my respectful submission, that was a submission that was accepted by the learned judge below and which informed her conclusion, which drove her conclusion. Back to page 50.
Well, it certainly would be right to say the purpose of planning is no longer stated to be a statutory purpose.
Quite so. But
that would be correct, wouldn't it?
It would, but it's a completely different thing with respect entirely. Because if it's still there as the statutory purpose, so often statutory purposes are not made express in a statutory provision, but they are nonetheless relied upon and applied by the courts, as was the case in the RMT and London Underground case that we'll see shortly.
So do you give any significance to the fact that the words are removed?
Not as regards the statutory purpose, no. And I will take you through an analysis which I submit explain why it was removed and why that has nothing to do with a variation in the statutory purpose.
Just kind of want to know, you give no significance to the removal of the words, right?
As regards the statutory purpose. Of course, I'll explain that there is a good reason for it, but it's not to do with the alteration to the statutory purpose. Before I leave the learned judge's judgment, at paragraphs 80 and 81, she observes that one gets help from paragraph 124 of Lord Justice Elias's judgment in RMT and Circa, in which he said that there is no statutory obligation requiring the union to use any particular category of jobs, and therefore there is no obligation to adopt the categories used for pay purposes. Indeed, there is clear authority that the only obligation is to provide numbers by reference to general job categories. And she goes on, the dichotomy described by Lord Justice Elias is not the same in this case, but it's a clear general approach. And I will also make submissions on that passage in the RMT and Circa case. And then finally, she considers that the decision of Mr Justice Chowdhury may well be authority for the proposition that the trade union is required to provide, in the case of pilots, a categorisation that enables the employer to know if those pilots are captains or first officers, or senior first officers. But she doesn't consider that it's authority for any wider proposition than that, and she wasn't satisfied that Mr Justice Chowdhury was taken to the very important changes in the statutory language, that is, removal of the planning purpose. May I just add that Mr Milford and I have checked back on the transcript of the hearing before Mr Justice Chowdhury, and the argument that was advanced in this case about the legislative history was not advanced in that case. We say for a good reason, because it's not an argument that's ever occurred to anybody before, but it wasn't advanced before Mr Justice Chowdhury, which is why it's not addressed by him. And my Lord, just to deal with the point raised by my Lord Justice Davis, in my learned friend's skeleton argument, at least as I read it, they are contending that that there is no longer a statutory purpose to help the employer to plan, and therefore the obligation should not be interpreted in that way. Can I show you what it is?
I made clear our cases as it was put by my Lord Justice Davis. We say it's not an aid to construction.
Should we just carry on and then you can say what you want to say in the round moment? Yeah.
May I then take the court through the iterations of the statutory provisions? And the best way to do this, if I may say so, is to use the documents that were added at the end of the bundle by my learned friends yesterday, I think it was, in tab 15, because we have one after the other the three versions. So what I think the court will have is a divider at the start of tab 15, and then within it, page numbering in red at the very top of each page.
Yes, where do you want to go?
To the page 1.
Page 1, yeah.
This is the first version of section 226A. It wasn't actually there when Tolkra was first enacted in 1992. It was enacted by the Trade Union Reform and Employee Relations Act 1993, which is called Torera. But this is the first version.
And this came into effect
In 1993.
the actual date?
30th of August.
30th
30th
of
of
August. I just want to note it down. Thank you. 30th of August, thank you.
And it provides in 226A1 that not later than the trade union must take such steps as are reasonably necessary to ensure that not later than the 7th day before the opening date of the ballot, the notice specified in subsection 2 is received by, I paraphrase, the employer. Then at 2, the notice is a notice in writing stating that the union intends to hold the ballot and specifying the date which the union reasonably believes will be the opening day of the ballot, and at C, describing, so he can readily ascertain them, the employees of the employer who it is reasonable for the union to believe at the time when the steps to comply with that paragraph are taken will be entitled to vote in the ballot. And then there's nothing more about the scope of the obligation. So at this stage it was a very high level obligation, if I may put it that way. It didn't refer to categories and it didn't refer to lists.
Yep.
This is version 2 is at page 4, and this was introduced by the Employment Relations Act 1999, and I think took effect from the 18th of September 2000.
18th of
September 2000.
Thanks very much.
So this is what I've been calling version 2. And subsection 1 is the same. Subsection 2 provides that the notice referred to in paragraph A is a notice in writing. A and B are the same, stating that the union intends to hold the ballot. B specifying the date which the union reasonably believes will be the opening day of the ballot. But C is different. Containing such information in the union's possession as would help the employer to make plans and bring information to the attention of those of his employees who it is reasonable for the employer to believe at the time when the steps to comply with that paragraph are taken will be entitled to vote in the ballot. So that's the reference to the purpose as being to help the employer to make plans, bring information.
Well, the actual obligation is linked to the purpose of enabling to plan.
Yes.
So that is linked by the wording of the section.
Yeah.
Right. Yep.
But as we will see, courts in the past have said that the same statutory purpose applied all the way through these iterations. But that's not where it ends. Over the page at 3A, it says that these rules apply for the purposes of paragraph C of subsection 2. So that's the general purpose and the general obligation at 2C. These rules apply for the purpose of it. A, if the union possesses information as to the number, category or workplace of the employees concerned, a notice must contain that information, brackets, at least, close brackets. Now that word at least, those words at least, mean that there is no hard-edged boundary to the obligation. You've got to give number, category, workplace, but that's just at least. And so you're brought back...
It's just a recipe for trouble, isn't it?
It is.
This sort of language is
terribly
a recipe for trouble.
badly drafted provision, if I may respectfully say so. Then at B, for the first time, it's stated plainly that if a notice doesn't name any employees, that's not a breach. But the main difficulty we have, as my Lord Justice Davis has noted, is that a combination of 2C and 3A doesn't set any helpful parameters at all for the benefit of unions and for those who want to work out whether the obligation has been complied with. As I put it in my note, it's an open-ended obligation.
Yep.
And may I just note that in 3A, 3 capital AA, even in relation to category or workplace, it doesn't say what the information about the category or workplace should be. Nowadays, it's the identification of the category, identification of the workplace, and the numbers in the categories of the workplace, but not even that is made clear in version 2. Then we have version 3, which is at page 7, and this was brought in by the by the Employment Relations Act 2004, but with effect from the 1st of March 2005. 1st of October 2005, my apologies. Now what one sees here is a complete redrafting, tightened up and restructured. And there are 7 changes that I'm about to enumerate. First, there is no reference any longer to the statutory purpose and no reference any longer to at least. And what that means is the boundaries, the outer limits of the obligation are made now as being the categories, workplaces and lists. The third change is that there are special provision for check-off. So in subsection 2C2 and then subsection 2 capital C, there are to enable the employer readily to induce the information the employer would otherwise have had to been entitled to. The fourth change is that there is a qualification at 2D that the information that the union has to supply must be as accurate as is reasonably practicable in the circumstances, in the light of the information in possession of the union. So there's not an absolute perfection in terms of the quality of the information. Fifth change is at 2E, they have defined what is meant by information in the possession of the union. So no longer can it be said that if explicit than it was previously, that nothing in this section requires a union to supply an employer with the name of the employees concerned. So there is a root and branch by the inference that the statutory purpose has been altered between version 2 and version 3. And therefore nothing to justify the conclusion that the statutory purpose is no longer to assist the employer to make plans and communicate with the employees.
I do find the phrase statutory purpose capable of being ambiguous. Do you mean the rationale underpinning the statutory?
Well, I drive is because I don't want to make any concessions that it's a rationale, not a purpose. And I say that it's really right at the very heart of the understanding of this legislation.
Would you say it bears on the meaning to be given to the word?
Yes.
How?
Because, as with so many pieces of legislation, a court that is charged with interpreting and then application has to bear in mind the statutory purpose. Sorry, I'm back to that phrase again, but bear in mind the statutory purpose in order to understand what the scope of the obligation is. It gives you a yardstick, as we put it in our skeleton argument, for what the scope of the obligation is.
Well, this kind of general approach leads one to conventional arguments, often address court. Give the words a purposive interpretation. That's understandable. But ultimately, we have to look and see what Parliament...
Whether I should do that now or give my explanation for why version 2 morphed into version 3. I'm going to do that first if I may, but I do promise that I will come.
I'm not saying for one moment this is a Pepper and Hart case, but has anyone looked at the parliamentary debates on these alterations?
Yes, we couldn't find anything.
Couldn't find anything yet.
There are, my learned friend has drawn attention to consultation documents.
Yes.
And we've also got the explanatory note.
Yes.
We submit that they're completely consistent with our submissions,
But
that there's no...
People have trawled through the parliamentary debate, nothing, even if it were admissible, which it might not be, which is my point. Right?
No, very much.
So, where do you want to go next? Explanatory notes or where?
No, so what if I may, my lord, what I'm going to do now is make submissions on why version 2 became version 3 and why it wasn't, because the statutory purpose changed. If the court will forgive me for using that phrase, but I will try and justify myself later on. There was a good reason to delete the reference to purpose in version 2, but it's not because that's ceased to be the purpose or that there's a new purpose. Rather, the reference to purpose in version 2 was part of the problem. It was part of the reason the language was so loose and nobody really understood so the statement of purpose in 2C in version 2 was part of the reason that the test was so uncertain. Combined with the words at least. So in other words, the statement of general purpose in version 2 went hand in hand with the rules in subsection 3A, and in particular the words at least, because in order to make any sense of what at least means in this context, the statute had to spell out the purpose, or felt it had to spell out the purpose of the obligation. So, in other words, the statement of purpose in version 2 was an integral part of the problem. And one thing I think we're all agreed upon is that the aim of version 3 was to tighten up the language so as to clarify the nature of the obligation. And it does so by being specific about lists and about categories, workforces and overall numbers. But since it has replaced the general obligation in version 2 with specific requirements in version 3, there is no longer any place for a statement of purpose in a general type in version 3, and indeed it just wouldn't fit with the new structure of version 3.
Well, it could have said lists including categories and workplaces and numbers, such as would help the employer to make plans and bring information to the attention of those of his employees who it is reasonable, etc., etc. If there was still an intention to link the purpose of the planning purpose to the nature of the information that must be provided, that could have been said, but it was deliberately deleted.
It could have been said. It would have made what's a long and complicated provision even more long and complicated. And the premise of that question, if I may respectfully say so, is that the planning purpose is no longer the purpose. So either there is no purpose or there is a different purpose. And as I will come on to submit, neither of those can work. That the only purpose logically in our respectful submission that can justify this imposition of an obligation on a trade union is in order to help the employer to plan. But yes, of course, those words could have been.
And how far it is required to help is the subject of the legislation. So the obligation is simply that set out in section 226A, no more, no less.
Yeah, provided one understands what categories mean. And that's why we're all here, because there is no definition of categories, and categories must mean something.
But couldn't it be said that you, a sub silentio, seeking, not deliberately of course, to reintroduce all the difficulties that the amending legislation was designed to overcome?
Not at all. What my learned friends are doing are saying categories is whatever the union wants them to be. So they are creating a subjective test, which means nothing at all. But we are respectfully saying that you have to find a yardstick for what is the right categories. And the yardstick is the statutory purpose. And we respectfully submit that the very fact that the amendment has been made in relation to Chekhov reinforces that what this is actually all about is helping the employer to plan. Because the burden for employers in unions, in workplaces which are full of people who've used Chekhov is reduced, because in those circumstances the employer doesn't need all the full panoply of categories and lists in order to plan, because it has the information already in its possession. And may I now take the court to the explanatory note, which, as my learned friends quite rightly say in their skeleton argument, can be used as an aid to construction, which is at page 16 in this part of the authorities bundle. The first point to make in relation to the explanatory notes is that nowhere in these notes does it say that the legislative purpose has changed in any way. It doesn't say there's a deliberate decision to alter or vary or eradicate the statutory purpose. What it does say at paragraph 141 on page 17, yes, of course, 137, the review of the 1999 Act and consultation process found that following the amendments, these provisions were generally working well. However, the judgment in the RMT case highlighted a difficulty with the way in which information required to be given in ballot and industrial notices should be presented. That's all. So we'll come to the RMT case in a moment. But paragraph 141 states that section 22, which is the one that introduces the changes, simplifies the requirement of section 226A by making changes to the information the union is required to supply. The changes make it desirable in the interest of clarity to restructure the provisions of the section, and the section therefore does so. So in our submission, that's completely consistent with what we say is the reason for the changes. You no longer need to set out the purpose. Indeed, it doesn't work in the new structure to do so. And at paragraph 143, which is specifically the paragraph that deals with the lists and categories and workplaces provision, having set out what it says, halfway down it says, the intention is to reduce the uncertainty currently present in section 226A by making the information that the union must supply specific and removing the need for the union to determine what information has to be given by reference to what would help the employer to make plans and bring information to the attention of those to be balloted. And then it goes on to dealing with the check-off provisions. Now, the reference there to removing the need for the union to determine what information has to be given by reference to what would help the employer to make plans and bring information to the attention of those balloted is plainly a reference back to version 2. And as I keep saying, the problem with version 2 is that it linked the general obligation to an obligation to do certain things at least. So there was no parameters to speak of in the provision. So we respectfully submit that these passages support our submission because we say that this is all about simplifying and restructuring the obligations. It's not about changing the legislative purpose. May I now ask the court to turn to tab 2, and I am now going to start with the two, what we say, the two key authorities of this court. This was a case about the balloting, about the categories requirement.
Tab 3.
Tab 2.
Tab 3.
Oh, I'm so sorry, I may have it in the wrong tab if it's in tab 3.
Is it the London Underground case? Or?
Yes, it is tab 3, I do apologise.
That's right.
So this is a case, I'll show you in a moment, it was when version 2 was in place. But at paragraph 19 we can see what the problem was. It was a London Underground dispute, and at the last 3 lines of paragraph 19 on page 653 we see that what the union said was the ballot will be of all members employed by London Underground in all categories at all workplaces. A bit optimistic, but that was the issue before the court, whether this was sufficient compliance with section 226A. At paragraph 11 in the judgment, page 650, Lord Justice Robert Walker, who gave the judgment to the court, as one sees, Lord Justices Dyson and Aldous agreed with him at the very end of the judgment, says at paragraph 11, the relevant sections of the 1992 Act are 226, 226A and 234A. The last 2 mentioned sections were inserted by the Turera in 1993. Section 226A2C and the very similar provisions in 234A have been further amended with effect from 18th September 2000 by the Employment Relations Act 1999. These amendments are incorporated into the text of the relevant provisions which were set out by the judge in his judgment, which must now be set out again. And then 12 and 13, his lordship sets out what is version 2. If I could ask, I mentioned that there was a problem with the list of categories. That wasn't the only problem in this case. If one looks at paragraph 37, there was a dispute about what was meant by information being in the possession of the trade union. You recall that's been clarified by the new legislation. But essentially, the question was whether the union should proactively have searched out for information, or whether it was enough, or which parts of the information in the union's possession, in the broadest sense, counted for these purposes. And it is in relation to those two issues that the court's conclusions are set out at page 660. 45 to 48. Although these 3 points, these are the points about, well, we can see the 3 points at paragraph 43 at the top of the page. These are about what amounts to possessing information. And the third one is the question of how far you've got to go in categorising. So this court then was dealing directly with what the categorisation requirement entailed. And at 45, Lord Justice Robert Walker says, although these 3 points were argued as separate points, they must all be approached, in my view, by considering the legislative purpose of the amendments made by the 1999 Act. Under the provisions in their original form, the clear legislative purpose was to enable an employer to know which part or parts of its workforce were being invited to take industrial action in order that the employer could first try to dissuade them, and secondly, and in so far as unsuccessful in its first aim, make plans to avoid or minimise disruption and continue to communicate with a relevant part or parts of the workforce. So pausing there, the point that I hope, or I fear obvious point that I make, is that he's referring there to version 1, which didn't have the statutory purpose spelt out in it. So even then, the statutory purpose is what we say it is. Then at 46, after the concerns expressed by this court in the Blackpool case, that was primarily about whether the obligation extended to naming names, and no doubt for other reasons also, Parliament altered the legislation by the 1999 Act to version 2 so as to make plain that a union could not be compelled to provide a list of names, and if the defendant union had given names, it seems likely that London Underground and the other claimants would have continued their previous practice of themselves annotating the list with grades and workplaces. This is the key point in the next sentence. But there was not any significant change in the legislative policy or in the purpose for which information was to be given to the employer. So at that stage, it's only version 1 and version 2, but his lordship...
Well, you'd rely on the next sentence as well, wouldn't you?
Of course, absolutely, my lord. So the change was a change of means, not of objective. And more than that, I rely on 47 and 48. If the amendments are approached in that way, it becomes clear that the judge was right to interpret information as to the number, category or workplace of the employees concerned in such a way as to provide the employers with information which was useful to them. So this is put much more elegantly than the answer I attempted to give to my Lord Justice Hamblen earlier on about what the use could be made of the legislative purpose. It informs the understanding of what needs to be done. And at 48, to that extent, subsections 3A and 5A must, in my view, be interpreted in the light of the legislative purpose, which has always been inherent. Again, I emphasise that melodramatically, but which has always been inherent in sections 226A and 234A, and which has now been spelled out in the amendments. At 49, he deals with a proposition or a submission that was particular to version 2, but explains the problem with version 2. Mr. Hand was counsel for the Union, submitted that the construction would deprive the statutory language of any force. That submission calls for serious consideration, but I would not accept it. In practice, in many cases, the Union will no doubt discharge its obligation by providing the irreducible minimum of information, but the words "at least" in the subsection point to the possibility that there may be special circumstances in which a union would have to do more. So even beyond categories and workplaces, there is an obligation, or there was in version 2 potentially, an obligation to go further than that. And as the court will no doubt have guessed from those passages at the very end of the judgment, 62, his lordship dismissed the union's appeal on the categories point and the two other points that were taken in that appeal. So that case, for obvious reasons, I rely upon for the legislative purpose, but I recognise it was a case which only considered versions 1 and version 2. There is a case of this court that considers version 3, and that's the RMT and Serco case.
Justice, could I, it may only be labelling, but, and of course we're now dealing with the more updated version, but would you label this case as a, quotes, special circumstances, close quotes case?
No, because the special circumstances, my lord, he was dealing with there were to do with the words at least. It was recognising that in version 2 you might have to go further.
But you're not saying that this present case, the British Airways case, you're not saying that it's to be treated as in some way an exceptional case?
No. We say it's a paradigm application.
You say it's a paradigm?
Yes.
Yeah, sorry, where are we going to next?
Tab A.
Thank you very much.
RMT, as is so often the case, is a party once again, but this time it's often known as the Serco case. There were two consolidated appeals. There were a number of challenges by the employers to the trade unions in this case, but for present purposes, what matters is that some of the challenges, this is by now version 3 is in force, some of the challenges were to the employer's compliance with the notification requirements in 226A, particularly on the basis that the union should have proactively kept lists of categories of worker and of workplaces of worker which it could then draw upon to, when the time came, to ballot for industrial action. So one of the central questions in the Serco case is whether section 226A should be interpreted so as to impose an additional duty on the unions to make up records which it could then hold and draw upon when the time came. Not an issue in this appeal, but can I show you paragraphs 41 to 43 in the judgment? Again, a judgment of the court, this time by Lord Justice Elias with Lord Justice Etherton, as he then was, Lord Justice Mummery agreeing. At 41, the first challenge was that the ballot notification included neither an accurate nor an adequate explanation as to how the union had determined what members ought to be balloted, and therefore the union was in breach of 226A 2C. Now that refers to a provision that I haven't really highlighted in section 226A, which is that not only does the union have to provide this information, but it has to give an explanation of how it came to the information, how it obtained the information. Not a live issue in the present case, but that was one of the issues in the Serco case. Secondly, at 42, the argument by the employer was that the figures were not as accurate as reasonably practicable as is required by section 226A 2D. But 43 is important because this is what was the error into which the learned judge fell. The learned judge in the first of the two cases considered that had the union implemented proper procedures, they would have picked up the errors so that the information could not be said to be as accurate as reasonably practicable. The assumption here, therefore, is that the union ought to have had this information in its possession, even though it did not in fact do so. So the reasoning of the judge that was being challenged in the Court of Appeal is that the trade unions had a proactive duty to have the information to hand, which it could then refer to. And the analysis of the legislative purpose took place against the background of that argument. And it starts at paragraph 58 on page 864. The judge found that the union would be likely to fail to show that it had complied with its duty because the information given in the ballot notice was wrong that had proper systems been in place or further appropriate investigations made, it could have been corrected. The assumption is that there is an obligation imposed by 226A either to keep accurate records or alternatively to acquire further information if the information which the union has is not as accurate as is reasonably practicable. In my judgment, the issue arising with respect to this particular ground is whether the section does create such a duty. So that was the point at issue in this relevant part of the case where His Lordship goes on to deal with the legislative history. And at 60, he says, in my judgment, the legislative history of the notification requirements sheds some light on the answer to this question. A union calling a ballot will know which members it intends to ballot and will have, with greater or lesser degrees of accuracy, their postal addresses. And then at 62, having referred to the Blackpool and Filed issue as to whether you had to give names, a further amendment was made in 1999, and the duty was framed in a different way. So this is version 2, and then he sets out what version 2 was at the top of 866. And at 63, His Lordship says this: this formulation identified the purpose behind these statutory notices, and it accurately reflects the current rationale. And I rely upon that. Sorry, I should go on. It is so that the employers can make plans to minimise the effect of the strike and contact employees to seek to persuade them not to heed the strike call. So, as I hope the court will appreciate, I rely upon this paragraph to submit that the view taken by this court in the Serco case was that the current legislative purpose, the rationale, is what we respectfully say it is, but not what Mrs Justice Elisabeth Laing regarded it as being. And at the last sentence of paragraph 64, against that legislative purpose, His Lordship concluded that there was no duty positively to create information being created. And at 66, he refers to version 3 coming into force. 92 Act was further amended with effect from the 1st of October 2005. Those are the provisions currently in place. As we have seen, they do now contain a definition of information in the possession of the union, and it's narrower than that proposed by the Court of Appeal, both because it restricts the information to that held for union purposes in documents and discs, and it limits the range of persons who are deemed to be the union for these purposes. Two other material differences, both of which I've mentioned: the reasonable practicability qualification and the obligation to give an explanation as to how the figures have been arrived at. And at paragraph 70, His Lordship sets out his conclusion on the point in issue in that appeal. He agrees with counsel for the union. Mr. Bayer, for the employer's argument, simply fails to give any weight to the fact that the reasonably practicable duty is limited by reference to the information possessed by the union. If Parliament had intended there to be a duty to create records not otherwise available, it would have said so unambiguously. But 71, furthermore, in my judgment, the legislative history supports this approach. The changes made for version 3 were intended, at least in part, to deal with the difficulties raised in the RMT case we've just looked at. It would be surprising if they were intended to make the burdens on the union more onerous than they had been by creating a fresh duty to obtain information. I accept that there will be a duty on the union to obtain any relevant documents from union officers and employees, and to collate and analyse that information to enable it to supply the relevant lists and figures to the employer as accurately as it reasonably can. Moreover, it would, in my view, be in breach of the duty to provide information drawn solely from documentary records when the union knew they were wrong. The duty is more than simply to replicate in a mechanical way the information in the union's possession. However, in my view, what was required, as in the previous incarnations of this duty, is that the union should assist the employer by drawing upon information it already has. So again, there's a reference to the legislative purpose being for the union to assist the employer. And then if I could ask the court to move on to paragraph 89, starting at 88 at the bottom of page 871. He now comes on to the next criticism, which was that the union hadn't given a full enough explanation of how it had obtained its information. I turn to the appeal against the judge's finding that the explanation was inadequate. This raises the question, how detailed must the explanation be? Parliament provides no direct assistance. The statutory obligations expressed in economical terms. The starting point is that the union has to provide information about a fact, how it arrived at the figures. No express obligation to provide information about how it kept its records, etc. And 89, next few lines. No doubt in construing its meaning, regard should be had to its purpose, but what is its purpose? This is not entirely clear, but I think some indication can be gleaned from the legislative history of section 226A, which I have set out above. So this is an example, it's a different part of the section, but an example of the legislative purpose being prayed in aid to construe the meaning of the provision, which is what, of course, I'm inviting this court to do in the present case. Whilst I'm at the London and Birmingham Serco case, may I take the court to the passage that Mrs Justice Elisabeth Laing regarded as helpful, which is on the very last page. It was the respondent's notice, that is the employer's respondent's notice in the RMT appeal. And may I just very briefly read the three relevant paragraphs. The complaint here was that the union in its statutory notices identified 3 categories of workers out of a total of over 50 categories, which were not identified in the pay rate spreadsheet which the union and employer jointly used for determining pay rates. As I understood the point, Mr. Bayard, for the employer's principal complaint, was that the union had provided confusing information because some of the job categories reflected those found in the spreadsheet, indeed the vast majority, but some did not. It was therefore a hybrid list with no consistent underlying principle of categorisation. In fact, the argument before the judge appears to have focused on a rather different point, namely that the union should have used the same job categories as had been used in the agreed list. It appears that what the union in fact did was simply to ask the employees affected what were their jobs. For the most part, their answers reflected the spreadsheet categorisation, but not in all cases. Whether the employer was generally misled is a matter of dispute, but it's accepted that any difficulty related at most to a handful of staff. This is now the passage that was set out in the judge's judgment. There is no statutory obligation requiring the union to use any particular category of jobs, and therefore there is no obligation to adopt the categories used for pay purposes. Indeed, there's clear authority that the only obligation is to provide numbers by reference to general job categories, see unison, and these will not reflect the more sophisticated job breakdown typically used in pay negotiations. Furthermore, the approach adopted by the union was, in my view, perfectly sensible and did not infringe its statutory duty. The union didn't seek to use a hybrid system. It notified the employer of the jobs identified by the workers themselves. Whatever difficulties that might cause an employer in marginal cases, I'm satisfied that it complies with the statutory obligation, therefore permission is refused. Now this was a case, I'm sorry I said it was the RMT case, this one wasn't, this was the ASLEF case. So this was a case where all of the individuals were train drivers. Nonetheless, ASLEF had given 50 categories in its notice. So it's not a case in which there was a very limited attempt on the part of the union to comply with its obligations. The complaint the employer was advancing was that the union should have used exactly the same categorisation as was used for a very specific purpose, which was pay negotiations. And rightly, if I may respectfully say so, the Court of Appeal took the view that there was no obligation to use exactly the same categorisation as was used in the pay negotiations for the purposes of section 226A. But this was a, if I may say so, rather optimistic submission on the part of the employer in this case, because actually what the union did was give 50 different categories. And so it wasn't really a challenge similar to the present case of failing to comply with the statutory purpose, as I have invited the court to conclude that it is. And so in our respectful submission, the learned judge in her judgment in the present case, at tab 5 of the core bundle, was wrong to say that any general help can be obtained from these paragraphs in the Aslev case. This is a very specific complaint which was dealt with in a very specific manner by the Court of Appeal, but which doesn't shed any light on the more general approach to cases such as this. In our respectful submission, the consequence of the interpretation of the legislation by Mrs Justice Elisabeth Laing and the consequence of her rejection of the statutory purpose, the legislative purpose, as I have submitted it should be, is that the requirement is, if I can put it this way, floating in thin air. It doesn't go anywhere, it's got no purpose, it's got no value. In which case, why is it there at all? As her ladyship said in the judgment below, referring to Lady Justice Smith in another British Airways case not involving ballot, the purpose of this legislation is not to create unnecessary hurdles for trade unions, and we quite agree. But this isn't an unnecessary hurdle, this is something with a point. But if you reject the legislative purpose of assisting the employer, then it ceases to have any point at all. It becomes an arid and meaningless and pointless technicality. And now I come to do with the point that I flagged up to my lady some minutes ago, which is the structure of this section of TOLCRA, the structure of the balloting and notification legislation, because I respectfully submit you can divide the purposes of the various parts of this legislation into two. Some of it, most of it, is to regulate the ballot and the activities of the union towards its members with a view to ensuring that the balloting is done properly and the industrial action genuinely does have member support. And I don't think it's necessary to take the court through it, though they're all in the first part of the authorities bundle. So this is where the requirements for there to be a ballot, to appoint a scrutineer, to allocate the entitlement to vote only to those who are going to be called to take part in industrial action, the mechanism for separate workplace ballots and special rules. Sorry, perhaps I'm going too quickly. I can give the court the statutory provision references for these. Section 226 is the requirement for a ballot. Section 2262B is the requirement to appoint a scrutineer. Section 227 is a requirement to grant entitlement to vote only to those who will be called to take industrial action. Section 227 is the default provision for separate, 228, is the default provision for separate workplace ballots. Section 228A permits unions to aggregate ballots between different workplaces in certain specified circumstances. Section 229 imposes requirements about what the ballot paper must say. It has to warn employees they'll be in breach of contract, things like that. Section 230 is about conduct of the ballot, secret ballot, and so on. Section 231 is about members being notified of the result of the ballot. 232A reinforces that members not entitled to vote can't be induced to take part in industrial action. 233 is about which trade union officials can call the actions, they have to be senior. And 234 is about the effect of the ballot lapsing after 6 months. All of these are to ensure that the industrial action has genuinely got the support of the relevant employees, and they all regulate the the ballot and help to ensure that union members know what it is they are voting for. Section 2268 is in a completely different class. It is one of three provisions, all of them introduced in 1993, which are about imposing an obligation on the union to help the employer out by giving the employer information. And the three provisions are Section 226A, Section 231A, which is the one about employers having to be notified immediately of the result of the ballot, and Section 234A, which is the requirement to give at least 2 weeks' notice to the employer of the industrial action and information about whether it's going to be continuous or discontinuous, categories and lists and all the rest of it. So the reason I've given this extremely speedy overview of the legislation is to make this submission, that where Section 226A is concerned, where the obligation is to notify the employer of certain matters, the only purpose behind it is to help out the employer, is to, of course, the union ideally would rather not have to do any of that because the action would be more effective, but the union has to do it because that's what the statute requires it to do. And those three provisions in my respectful submission, which are part of a package, have a single statutory purpose, which is to enable the employer to plan and, so far as possible, to intercede with the relevant employees to persuade them not to take part in the industrial action. And in our respectful submission, that's consistent with what this court has said in the RMT and London Underground case, and subsequently in the RMT and Serco cases. And understanding that that is what the purpose is a necessary yardstick to enable the court to evaluate in a particular case whether these requirements have been complied with, and particularly whether the undefined categories requirement has been complied with. The next thing I'll do, and I can do this I think in a very few minutes, is to deal with the other authorities. So may I ask the court to turn to the...
Could I just ask you this? You haven't taken us to the actual ballot information given to BA by BALPA. Speak myself, I have looked at it. But are you saying what was there provided by way of information in terms of categories and numbers by BALPA, are you saying that was of no value?
No, it was not of enough value.
No, but who decides what's enough?
The court decides when it comes to the court.
But you do accept that value was given. Some help was given
Of
by...
course, yes.
I thought the answer has to be yes. But I just want to be clear on that. Because I rather thought you at one stage said rather broadly that consequences of rejection by Mrs Justice Elisabeth Laing means the requirement has no purpose and no value.
Yes, but that is the consequence of her interpretation. Because if you follow the logic of her interpretation through, the union could have just said pilots, because that's the category in the broadest sense. So why is that not enough? Because you don't need to care about the...
So you do accept here that the information given in terms of categories numbers was of value?
Yes.
But you say, but it wasn't enough.
Yes.
And who decides then what more is to be given?
It's a question of fact and degree in the circumstances of each case. And therefore, if it's challenged, it's for the court to decide.
But that's presumed, is that a binary approach from the union? Does it have to say, yes, we must give this, or no, we mustn't? Or is it within the ambit of a reasonable discretion?
No, it's
absolutely binary. So the union were positively required to say which fleets and so on and so forth.
Yes. And in my respectful submission, this isn't a hard case, because the evidence accepted by the learned judge, which I haven't taken this court's time up reciting, showed that BA was organised by fleet, operations are organised by fleet. Indeed, the fleet information is taken by BALPA when pilots join. They ask them what fleet they belong to. And BA needed the fleet information in order to make their preparation. So it's not a technical or esoteric or empty point. It's a point that has real substance, because it really, really would make a difference to BA's preparations.
And just so and you accept, I've used the word which seems very modish nowadays, binary, but this is a hard-edged decision by the union. Either you must give it or you need not give it.
Yes.
There's no discretion, as it were. That's your argument, right?
And why is it the only way that the union could have approached the categorisation here, as contrasted with the Virgin Atlantic case, where the union was right, or was wrong not to give the information that was given here?
Yes, I probably my lady, I was counsel for the,
I know, you said so.
Virgin Atlantic case. That was different because we didn't need to worry about fleets. First of all, Virgin Atlantic is differently organised. It's, as you know, it only does long haul, as you probably know, it only does long haul, only has a few destinations. It's not a full service national airline like British Airways is. So I
But
don't
there
want
are
to breach any
four
confidence.
categorisations of long haul fleet used in British Airways
Yes.
that you say the union has to supply to be right.
And that's because in British Airways you can't swap pilots from one fleet to the other because of their they need 3 to 6 months retraining. In Virgin Atlantic, the problem was between pilots and first officers. So the problem was not different planes. The problem was that if you were a pilot, you couldn't sit in the other hand seat, and vice versa, without a similar amount of training. So in Virgin Atlantic, we did not need, we being Virgin Atlantic, didn't need to drill down into whether there was also a breach in relation to fleets, because in that case, the union, which wasn't BALPA, the union had not even given us the categories of pilots, and so forensically, I didn't worry about fleets. But in any event, they are different cases, and this is dealt with in Mr. Winstanley's first witness statement, around about 56, 57, somewhere about there in his statement. He explains briefly the difference between BA, which has, as you know, short haul, but also long haul and different sets of pilots, with an all long haul organisation such as Virgin Atlantic. But there is, frankly, a much more straightforward reason for why there was no need to get into the fleets problem with Virgin Atlantic, which was that they fell at the hurdle of not even categorising by
Well, in
pilots.
the Virgin case, if you couldn't win on pilots, you couldn't win.
Quite so.
And if you could win on pilots, that was enough your purpose.
Yes.
So your purpose for Virgin's purpose in
As I put it to my instructing solicitor, pilots was low-hanging fruit, frankly. The ranks of pilots. That was all I needed to show, but my lord is quite right. If we were either right on that or we weren't. So there's no inconsistency in our respectful submission between the Virgin Atlantic case and the present case.
Right.
May I take the court next to the Unison and Westminster Council case, which is at tab 4. This is a version 2 case, 2001. And much of it was about something of no relevance to present purposes, which is whether the dispute counted as a trade dispute. But the category issue also arose, in Lord Justice Pill's judgment, the first judgment, it begins at paragraph 45 on page 1057. And so it says the second issue relates to the alleged failure of the union to comply with the requirements of 226A. At 47, we can see what the union did, which was to categorise the employees as those staff employed within the assessment and advice unit, which was a particular unit within the council.
It goes on to say they can be described as A&A workers.
Yes. Which is assessment and advice workers, I think. Paragraph 56, or perhaps beginning at 55, on page 1060. I should start at 54. He's setting out the judgment of Lord Justice Robert Walker in the first RMT case. The legislative purpose was to enable an employer to know which part or parts of its workforce were being invited to take industrial action. And he goes on to say the word category was not defined by Lord Justice Robert Walker in London Underground, nor was it necessary for him to do so. Not necessary for this court to attempt a comprehensive definition. In my judgment, it's clear that the requirement was met upon the facts of the case, and that the requirement as to category was sufficiently met in the information provided. So, pausing there in my submission, the approach his lordship has taken in that case is to regard it as a question of fact and degree, dependent on the facts of that particular case. Of course. I'll read the rest of the paragraph. The number of staff involved was only 45. They were identified as assessment and advice workers. The relevant staff are said to be those in the assessment and advice unit. Was not identified by name. Information was provided by reference to, that's Chekhov, by which the individual identities could easily be ascertained by the employer. It's not suggested that different professions or trades are involved within the assessment or advice. And then in paragraph 57, last sentence, last two sentences, he says, in my judgment, given the information supplied, the requirement as to category was sufficiently met in the notice. I bear in mind the purpose of the requirement in section 226A, as stated by Lord Justice Robert Walker, and with which I agree. So that's another occasion in which a judge in the Court of Appeal has agreed as to what the statutory purpose is, albeit version 2 was in force at the time. As for Lord Justice Mantell, he simply says this at the bottom of the page. As to the second issue raised in the appeal, I have nothing to add to what has been said by Lord Justice Pill. And it's worth noting, therefore, that he doesn't say anything about what is said by Lord Justice Buxton. And Lord Justice Buxton deals with the matter at page 1063. At paragraph 78. And again, he makes reference to the London Underground case, and against letter F, he says the reason why notification is required is to enable, amongst other things, the employer to make plans in relation to proposed action. I will assume that that is directed at his ability to cope with the practical difficulties caused to him if the action takes place. For that purpose, he needs to know who is going to be on strike and who is not. What the union has to tell him, if it knows, includes the categories of employees affected by the action. That, in my judgment, is a very broad word and not to be either exclusively or narrowly defined. It means no more than a reference to the general type of workers. In this case, by means of the reference to the deduction of contributions at source system, the employer actually had, or was given access to, a nominal roll, that's misspelled, of those who were going to be taking action. Something that was more than the statute in its revised form intended. And you can see at the start of the next sentence that the employer in that case was suggesting that details of job descriptions and status of employees needed to be given. And then finally at 81, if I'm wrong about that, the fact that the notice in this case provided, by a reference easily available to the employer, an actual nominal role, more than amply fulfilled any obligation placed upon the union by this statute. I would not want to be thought to be laying down any rule that goes outside the facts of this case, save to say that the obligations of the union must be assessed in the circumstances of the particular strike, and in a common sense way, I think that should be in the light of the policy of the legislation. In this case, that objective was achieved, and I would therefore allow the appeal on that ground also. So once again, in that last paragraph, his lordship is referring to two things. One is it's a question of fact in a particular case, and two, that you must assess the obligation in light of the policy of the legislation. As regards the statement in 78, which my learned friends latch upon, that he says that categories is a very broad word not to be exclusively or narrowly defined. In my respectful submission, it's to be borne in mind that at 81, he makes clear that he's not laying down any rule that goes outside the facts of that case. And in my submission, cannot possibly sustain a Barras argument. My learned friends put that version 3 must be deemed to assume that the word categories is a very broad word indeed, not least because neither of the other two Lord Justices approved this passage in Lord Justice Buxton's judgment. Two other authorities which are first instance only, but illustrations of what we say is the right approach. The next one is the EDF case, which you'll find at tab 5 in the bundle. This is the first reported case on version 3. Mr. Justice Blake. And the notice, the text of the notice is at paragraph 8. And it is, the members who will be invited to vote are all those members of this union employed by the company in the category of engineer technician. And in the preceding paragraph, there's a reference to this category actually consisting of 270 permanent staff employed in a variety of roles, no check-off, and specifically at Tufnell Park, there are fitters, jointers, test room inspectors, day testers, shift testers, or Olby fitters. In general terms, the employees at Tufnell Park are described as craft staff. Mr. Justice Blake took the view that this was not compliant on the facts of this case with the section 2268 obligation. Again, in my submission, it's an example of applying the law to the facts as a question of fact and degree, but his lordship directed himself by reference to the legislative purpose as described in the Unison case, and one sees that at paragraph 15 of his judgment, where he sets out a quotation from the Unison case, including the reference in paragraph 54 to the legislative purpose. And at paragraph 18, where he sets out his conclusions, at subparagraph 3, the right-hand column, he says, on these facts there is substance to the claimant's point that it would make a material difference to the employer if he had to face the risk, for example, of a test room inspector withdrawing his labour as opposed to a fitter. Although the court has not been informed in any detail of what the contrasting functions are, it's not difficult to imagine that they may have different skills, different roles in the operation, and the loss of one may have significantly different effects to the loss of the labour of another. And I make the forensic point that the loss of somebody in one fleet here will have, or may have, significantly different effect to the loss of people from different fleets. And at 19, he says, putting all those conclusions together, I conclude that in the present case, the particular descriptions that the claimant was seeking appear to fall into the category of trade rather than job description, and I conclude that the claimant has demonstrated that the requirement to give notice under 226A has not been met. And later on in this paragraph, he reiterates what he understands to be the legislative purpose, exactly halfway down. But I recognise that the Westminster case was in the context of a first stage duty the notification of the ballot. There is a clear nexus between the failure to discharge that first stage duty and the employer's ability to respond to it, either by making preparations in the event that a strike is called, or indeed making representation to those who are to be balloted as to why, in the particular circumstances, they might not want to vote one way as opposed to another. It's clearly, therefore, not a technical or immaterial breach in the present case. So this was another case in which the learned judge had taken account of the legislative purpose in coming to a conclusion on the facts of that case as to whether the categories requirement had been complied with. And the last authority is the Metro Line case, which is at tab 10 in the bundle. My learned friend Mr Ford was in this case. This is another version 3 case. And the battle lines can be seen from paragraph 24 of the judgment, Mr Justice Simler. The ballot notice sent to Arriva, these were people who worked at a bus garage. The ballot notice sent to Arriva stated that the union intended to send ballot papers to all members who were drivers, engineering grades and supervisory grades working on the TfL contracts, either on a full-time or a part-time basis, employed at the Watford depot. And just so the page, top of the page, at paragraph 31, the employer complained that he didn't know from the notices who had been balloted or who's going to be taking strike action. Makes it almost impossible for Arriva to plan for the impact of the strike action. He states, we do not know with any clarity what bus routes will actually be adversely affected. We do not know with any clarity what shifts are likely to be adversely affected. And again, same wording about ancillary functions likely to be adversely affected. And the learned judge found on the facts of that case that there was a breach of section 226A. One sees that at paragraph 61 in the judgment. I consider that the likelihood is that the union will fail to establish at trial that it complied with the statutory requirements in respect to the ballot notice. I've reached the same conclusion in relation to the strike notice. The claimants cannot readily deduce, in light of the statements made by the defendant, the identity of their employers. De minimis has no application. And 66, he rejects the proposition that because the union has given subsequent information that absolves it from the failure to comply with section 226A. So all of these cases, and I won't take the court's time up going back to the Virgin Atlantic case, but the same applies to that. All of these cases are cases in which three things can be said. One is that the court treated it as binary, two, which comes to the same thing, that it's a question of fact and degree for the court, whether there has been a breach of section 226A. And third, that in determining whether there has been a breach of 226A, the court must bear in mind, centre stage, the legislative purpose, which is to assist the employers. None of the cases contain any suggestion that the legislative purpose changed between version 2 and version 3, despite my being in the Metroline case. So far as those behind me as researchers have shown up, there aren't any academic writings that support the proposition that the legislative purpose has lapsed. And in our respectful submission, it is still as important now as it has ever been.
Do any of the textbooks comment on the meaning of section 226A?
There was a passage.
Harvey also.
Yes, there was a passage in Harvey that was referred to in the Virgin Atlantic case. That. But this is a passage. I think Harvey has since been amended because of the Virgin Atlantic case, but this prior to the Virgin Atlantic case.
Do we have in the Bundle Authorities the up-to-date version of Harvey on this?
No, we don't. We can make efforts to obtain it over the shorter journey if the court would like to see it.
And none of the other textbooks on it?
No.
Or discussed this point?
It's a relatively new point, of course, because the Virgin Atlantic case.
Well, the point has been there before. Obviously, the Virgin hasn't. But I think
those behind me have burnt the midnight.
I wouldn't mind getting it over the lunch jam.
We'll do that. But those behind me have burnt the midnight oil trying to find academic writings.
I'm sure a lot of candles have been burnt.
Yes. Any assistance, but without finding anything that does. May I just show the court the passage from Harvey that's referred to in the Virgin Atlantic case?
Yes, I chatted.
Tab 13, page 30. It's against the upper whole bunch. A category of employee for this purpose is to be understood as meaning the general label an outsider might use to describe the relevant workers. The union is not obliged to conform to the particular job descriptions used internally by the employer, but the degree of specificity required depends very much on the circumstances. As is so often the case, both parties prayed in aid. That passage is supporting their own position in the Virgin Atlantic case, but it's set out.
So you say that's consistent with the fact and degree approach?
Yes, and indeed it's in the context of the second proposition, which is the fact and degree proposition that Mr Justice Chowdhury adopted.
So what do you say category means, at least as a starting point, before you get to facts and circumstances?
Category means the grouping of workers.
Sorry, say it again. Category means?
Sorry, I'm just the grouping into which the workers are organised by the employer in a way that. Sorry, I'm not drafting very well on the hook. Which category meets the statutory purpose of assisting the employer to make contingency plans. I'm ashamed of myself for such a vague form of words, but I have an explanation for it, which is, as I've said several times already, that unless you use the yardstick of the statutory purpose, it's not possible to place a definition on categories. So categories has to be defined by reference to the legislative purpose.
Well, certainly Lord Justice Buxton had not been inclined to give a definition of categories.
No.
He just tells us not to be exclusively, I don't really meant that word, or narrowly interpreted, but he didn't go down the road of attempting a definition himself.
No, and of
perhaps
course
wisely.
The courts very regularly warn lower courts of the danger of putting a gloss on a statutory provision. Yeah. So I don't seek to put a gloss on the statutory provision. What I do seek, the court will be weary of me saying the same thing, but say that the word category, the meaning of category has to be understood by reference to the legislative purpose. So that's the yardstick. If we are right in our submission on the law, the learned judge below, we say, misdirected herself and applied the test against the wrong legal background. And we respectfully submit, and I'm not going to repeat what we've said in writing about this, but we respectfully submit that given the findings on the facts that the learned judge said about needing this information about fleets to plan, applying the correct legal test, the conclusion has to be that the union should have categorised by reference to fleet as well as by reference to rank. And it's not, that's paragraphs 13 to 15 of the learned judge's judgment, and this is not catching the union out or blindsiding them in any way. It's the way BA works through fleets. It's the way they information they take from their members. And we put it bluntly, as follows below. It would not have caused any inconvenience at all for BALPA to provide categorisation by fleet, but the failure to do so substantially exacerbates the disruption, inconvenience and stress for BA and its passengers.
But I would have thought most airlines will operate a number of different kinds of aircraft, say certain Boeings and then Airbuses. And a pilot who's trained to fly one will need to be retrained to fly another. So what you're saying would seem to have potentially quite large implications for at least the aviation industry and perhaps for other kinds of work as well.
Not so, my lord. The evidence about the short-haul fleets is that pilots could fly all the planes in the short-haul fleet. So there is no limit on the types of planes within the short-haul fleet the pilots can fly. In the long-haul fleet, yes, but this is not a massive burden for the union. This is information which they accept they have. It is the way that everybody is organised. Everybody knows what fleet they're in, and so it's not imposing granular or impossible restrictions on the union. And each case depends on its own fact. I can't speak for how other airlines are organised, but for BA, they need to know this in our respectful submission. And the union knew, or should have known, that they need to know this. And therefore, if the statutory purpose, what unlocks all of this is the statutory purpose point.
Why should the union have known that BA needed the information about fleet? We've seen the Virgin Atlantic case, and I appreciate what you said about not needing to go as far as to discuss fleets, and Virgin is differently organised in any event. But why should the union, as a binary matter, have known this?
Because it's a pilots' union, and because it's run by and run for pilots who understand how BA works, because it's not a technical secret behind closed managerial doors that the airline is set out by way of fleets. Our evidence was that pilots define themselves by reference to the fleet that they belong to, and it is, we respectfully submit, blindingly obvious that any remedial measures that BA would have to take would have to be fleet by fleet. You can't have a one-size-fits-all
Is it in the contract of are they recruited as a pilot
yeah, the
to a
fleet is
particular
mentioned,
fleet?
is stated in
It is.
the contract of employment. Yes, well, sorry.
Sorry.
Paragraph 6 of the judgment, thank you. Just contract of employment was in the bundle.
Yep.
Yes, when they're recruited, they're assigned to a particular fleet.
Well, they may be assigned to, but
Is it
do the contracts of employment.
It's in the bundle, the title bundle.
Is this bundle 1?
Yes, it's at page, it's in the exhibit to Mr. Stratton's witness statement, and it's at page 76.
Sorry,
Page 70, in mine it's 70.
76 is financial.
tab 11.
Tab, apologies, I got this time.
Over.
That's
It's the exhibit to Mr. Stratton's statement.
It's page 105 in the
Page
larger.
105.
All right, so this is the standard form.
Yeah.
Just a minute.
And the job title and duties is under 1, which refers to the rank.
And the contract for a captain is the same, in effect, yes. Is there any reference to, when you're on a fleet tour, is there any reference to fleets in this contract of employment?
No, it refers to place of work and nothing about fleets.
Yes.
And while you're on that, you might as well look at the previous page.
Sorry, which page? 104?
Yeah, which is Balfour's database. See, it refers to the rank captain in the first column, and then on the third refers to company, base and fleet. So that's where we said we did have the injunction there.
Sorry, where's that?
That's on the next column across, my lord.
Waterside.
Waterside and
Fleet.
But the risk of interrupting, can I show you one other document, which is British Airways Corporate Directory, how it records, which is at 85 on mine. Yeah, it's just after the contract. 114. And there's a captain.
It says Department Pilots A320. What does that signify? That's a kind of aircraft.
That's the A320.
A320 fleet, yes.
So the department is equivalent to the fleet on this.
Yeah.
My lord, sorry, I was wrong. It's actually in the letter of appointment that they're told what fleet they're in. Volume 1.
Volume 1.
Main of the evidence below.
Yep.
Tab 5 at page 181. This is the email appointment letter. Hi X. We are delighted that you've been successful in your application for the role of First Officer, DEP B787, that's the fleet, with us. And in the same...
DEP is department.
Department, yeah.
And at page 177 is the corporate directory for BA, and you can see at the top of it that it's edited by the pilots. So there's a box for update my details at the very top of the page. And this profile, this is just one of many examples in the bundle, this profile, including position and title, has at the bottom of the page Department Pilot 777. So again, the fleet is referred to. And just for the court's note...
Sorry, so who inputs the details into page 177?
Do you see at the top of the page, there's a blue box, update my details.
So it's the pilot who does it.
Who does it. And that's stated in Mr. Winstanley's own evidence, at paragraph 32, the same file, volume 4, page 8.
Where are you?
It's tab 4, same volume,
Tab 4.
page 8. Each pilot will be licensed on a particular type of aircraft, subject to short haul fleet, only operate those they are licensed for. When pilots are recruited, they'll be provided with notification of the fleet they've been assigned to. See the sample notification we've just looked at. Pilots see themselves as belonging to a fleet. See, for example, screenshots from BA's corporate directory, which shows a number of pilots referring to their department as being the fleet to which they're assigned. At the page we've just looked at, they report to managers within their fleet, a performance managed within their fleet, receive specific technical and training communications within their fleets, etc. And the next paragraph is about the palaver that has to be followed to move fleets. Now, none of this evidence was challenged or contradicted in Mr. Strutton's evidence for the union. May I turn my back for a second? I lost my lady, unless there's anything else on my submissions.
Thank you very much indeed, Mr. Governor. Of course, you will have the right to reply to Mr. Ford. Yes, Mr. Ford.
My lords, my lady, one matter to correct just before we carry on. Dep on the recruitment letter doesn't refer to department, it refers to direct entry pilot. My lord, I'm grateful to my lord for allowing us to put in the skeleton on Monday. Despite the additional time, there are still some typos in it. Can I correct those at the outset?
We're not worried about typos.
Fine. The skeleton outlines our submissions at paragraph 4. And the first two issues are the first two subparagraphs are the question of statutory construction. And we say that in 2004 there was a change of policy when Parliament deliberately, this wasn't an inadvertent change, deliberately removed the express reference to an employer as would help the employer to make plans. And when we look at the consultation papers, we'll see that the object of the changes was precisely to remove the uncertainty that that test would provide. Now, I'll come back to how Mr. Kavanagh puts it, but in broad terms, he says, well, those express words go, but then magically the inherent purpose to the same effect revives. And our short and simple point is that that would have the effect of contradicting the objective of the 2004 amendments. So that's why we say the term categories should be given its ordinary meaning, just as Mrs Justice Elisabeth Laing held, recognising always there are different ways of categorising employees, which inevitably entails a degree of discretion on the part of the union. The problem is categories cuts down the hierarchy, but also cuts across it. Grade, department, speciality, jobs assigned to. There are many, many ways of categorising employees. If we're wrong on that, and
So when you say degree of discretion,
yes,
you dispute Mr. Kavanagh's binary approach.
Yes.
He says there's a reasonable margin of error available to a union in deciding what information to give and what not.
yes, we say consistent with the 2004 changes, and with the approach of Lord Justice Elias in circa 124. This is an exercise, and with the code of practice, I should say. This is a question which the Parliament has, in the interests of legal certainty and practicality from the union's perspective, has effectively accorded them a degree of discretion.
But if you start talking the language of discretion, straight away talking in terms of uncertainty.
Well, not necessarily. It's certainty from the prospect of the union. What we're saying, the object of the changes was to make this question more certain and practical for the union.
For the union?
Yes.
Where do you get that from?
Well, we'll look at the consultation papers shortly.
I mean, by discretion, you mean there should be more than one way of answering
Exactly.
the
More
question.
than one way, okay.
Exactly. More than one way of categorising.
With the yardstick of reasonableness, but
Yes.
never.
Exactly. And The reason why that's right is because it's Mr. Kavanagh's interpretation, a question of fact and degree, that effectively places every case potentially in the courts. Because the union won't know what particular system of categorisation might assist a particular employer in making plans. Sometimes it will, sometimes it won't. It may be able to guess. So effectively, in every case, a union is going to have to second guess what are the employers, what planning needs does the employer have, so what categories are we going to give? And the answer is, you will pretty much say you're going to have to give every single piece of information you can conceivably find, because otherwise the employer may turn up and say, sorry, what you've given us isn't enough for your plans, for our plans, and therefore we needed a different system of categorisation. And to a degree the present case highlights that, because of course BALPA looked at PPU, looked at the Code of Practice, look at Serco, and say, well, they say Serco says general categories, PPU says this, we will give this, and then they're told that's not enough. It will recreate all of the radical uncertainty as to what is a category that the 2004 amendments were designed to remove. Effectively, we will be back where we were before Parliament made those changes. Now, my lords, my lady, the third and fourth points only arise, well, the third point, we say that even if categories is approached in light of the purpose, still the appellate courts, firstly in unison, the Westminster case, second, as endorsed by, secondly, Lord Justice Elias in. But that only arises if we're wrong on the primary point. Because on the primary point, we say, regardless of the precise route Mrs Justice Elisabeth Laing took, the clear object of the 2004 changes was to remove interpreting categories in light of information that would assist the employer to make plans.
But would you accept a union to give categories and lists to an employer?
Yes, but it
No. So would you accept that's the underlying
I accept
broad
that's,
purpose?
I accept that's the
Well,
underlying.
we've been using the word
You
rationale.
use the word rationale. I
Yeah.
accept that's the underlying rationale.
Yes.
But in my respectful submission, it's not an aid to construction of the word categories in section 226A. So it may be the underlying rationale, but the changes made by Parliament in 2004 show that that is no longer an aid to
So
construction.
when one acknowledges that the purpose of this is that which is in the section,
Yes,
no
just
more and no less.
exactly, just to provide categories, but not to do so as would assist the employers to make plans. Because that is effectively to reverse 2004.
If there is, as you argue, a kind of discretion, in your word, available to the union, is that not consistent with Mr Kavanagh's argument that it's a matter of fact and degree?
Not when it comes to whether cases end up in court, because so long as the union acts within a margin of reasonableness, gives a rational system of what could be described as general categories, we won't end up here.
Want to bet?
Possible to know with certainty what system of categorisation would be the one that assists the union to make plans. And the very purpose of the 2004 amendments was to make these provisions more certain and operable from the perspective of the unions. And one doesn't, there are other examples given in Mr Strutton's witness statement I'll come from shortly. There are multiple ways of categorising pilots. I could take the example of a nurse in the NHS. The nurse has a speciality, she's assigned to a department, she may be night or day, she may be part-time or full-time. I say she, excuse my department that she's working in. Categorisation is approaching, elusive and unclear concept.
Well,
The intention
the most straightforward way would be by name, but that's precluded under the statute.
and for obvious reasons,
reason,
because
right.
names sent us the problem with version 1.
Yes, yes.